Welcome, everyone. Let's get started. Savvy, you have the mic.
Hey guys, welcome, welcome, welcome. We are so excited that you could join our space today. We are very honored to have Dr. Robert Shapiro joining us, as well as attorney Wes Christian. We have a limited time today, so we're going to go ahead and jump right in. Let me let you guys know how the space is going to go. We are going to give a couple of biographies for our guests today, and then we are going to move into a summary of the MMTLP fiasco, and that will be delivered by 𝗪𝗧𝗪𝗧𝗪. Then we're going to roll into our questions. And, the title of our space today is The Anatomy of Market Fraud, the MMTLP Fiasco. So we will be asking some general questions about market fraud, and then we were going to roll into some specifics in regards to the MMTLP fiasco. And then we'll see where we go from there, guys. So again, welcome. We appreciate you joining us. And let me start, first of all, by welcoming Dr. Robert Shapiro. Dr. Robert Shapiro is a world-renowned economist who graduated from the University of Chicago, the London School of Economics and Political Science, and received his PhD from Harvard University. He is co-founder and chairman of Sonicon LLC, a private firm that provides advice and analysis on market conditions and economic policy to senior executives and officials of the U.S. and foreign businesses, governments, and nonprofit organizations. Notably, among many others, Dr. Shapiro has advised U.S. Presidents Bill Clinton and Barack Obama and British Prime Minister Tony Blair, New York Life Insurance Company, AT&T, and Google. Dr. Shapiro served as Undersecretary of Commerce for Economic Affairs in the Clinton administration, has been a fellow at Harvard University, the National Bureau of Economic Research, and the Brookings Institute. Dr. Shapiro, we're very honored to have you today. Welcome to the mic.
Thank you. I'm delighted to be here, but please call me Rob from now on.
Okay, Rob, I will do that. We're sticking with the three-letter names today, so that's fantastic. Appreciate it. Our second guest today is, of course, attorney Wes Christian. We are very familiar with Mr. Christian, but just a little about Wes. He is managing partner at Christian 𝗪𝗧𝗪. Mr. Christian is a civil litigator with 40 plus years of experience handling a wide range of complex litigations and arbitrations. Most recently, he has focused on taking on some of the biggest predatory stock market manipulators in both state and federal courts across 8 states and 2 countries. Recent clients include Genius Group, MULN Automotive, and MetaMaterials, Inc. And I know I've said this before, but I'm going to say it again. As a half Texan, I know Wes will take pride in and will appreciate me mentioning that he is a 4th generation Texas. So Wes Christian, welcome to the mic.
Thank you so much, and remember the Alamo. Okay?
Absolutely. So, guys, as I said, we're going to start off today. We know that we may have some visitors in our space today that are not exactly familiar with the MMTLP fiasco, because, of course, when you bring in someone like Dr. Shapiro and attorney Wes Christian, we're going to attract people from outside of our normal community. So we're going to start with an oral summary of the MMTLP fiasco, and that is going to be from our very own 𝗪𝗪𝗧𝗪𝗧𝗪𝗧𝗪𝗧𝗪𝗧𝗪𝗧, the mic is yours.
Hi, you guys. Thank you so much for joining us today. Just like Savvy just said, I'm sure everybody's pretty familiar in this space with the story of MMTLP, but there are new people popping in all the time. And for anybody that needs a refresher, basically MMTLP was born from 2 companies that merged back in June of 2021. One was a Canadian materials and science company, and they wanted listed on the NASDAQ. That's MetaMaterials, and they are now listed as MMAT. And they merged with a Texas oil and gas company that was Torchlight Energy Resources, TRCH. And one of the big things in this was that Torchlight Energy had discovered the largest on-land oil discovery in over 30 years on 137,000 acres of land in the Midland, Texas oil basin. And so when they did this merger, part of the agreement was that Torch would either liquidate their assets or they would spin out into a new and private company. And so any of the shareholders from Torchlight Energy that were holding Torch going into that June 2021 merger were awarded a Series A preferred share that was a placeholder, and it was not designed to be tradable, but it was a placeholder for when they either liquidated or spun out into that new company, that those shareholders would have a claim to whatever that, either it was a dividend for the liquidation or whether it was shares of whatever that new private company might become. And now we know that that company is called 𝗪𝗧𝗪𝗧𝗪𝗧𝗪𝗧𝗪𝗧𝗪𝗧. So those shares sat on our account for a few months. They weren't tradable and they weren't assigned any value. And all of a sudden, in October of 2021, on October 6th, these shares were assigned a value and they were openly trading on the OTC. In fact, John Berta was just as surprised as the rest of the shareholders when he found out as he was traveling. He immediately contacted FINRA. He asked, how these things were trading. He made some inquiries and essentially was told that they were going to continue trading and there was nothing that he could do to stop it. They traded for more than a year on the OTC. In July of 2022, MetaMaterials, the new parent company, decided to elect the spin-out option that they were given within their merger. And so they began the process of spinning out Torchlight Energy, or what was the Torchlight Energy assets, into what is now NextBridge Hydrocarbons. So the shareholders that have MMTLP, that goes through until November when that is approved by the SEC. MetaMaterials immediately contacts FINRA to request the process of a corporate action. And finally, on December 6th, the first corporate action is issued from FINRA, letting the shareholders know that the process that will take place, of which this finalization of the spin-out will take place, is going to go through, trading is going to go through December 12th. There will be no trading on December 13th, and this exchange of shares will happen on December 14th. So that was at the end of trading on December 6th. It traded through the 7th, and on December 8th, a new corporate action came out that said, and this was with 90 minutes left in the trading day, by the way, a new corporate action came out and it changed the language. Instead of it saying that the shares would be canceled, it now said that these shares would be deleted. And instead of saying that trading would be, there wouldn't be any trading on the 13th, and that shares would be exchanged on the 14th. Now it removed all of that. So now we have no exchange date on the new corporate action. 90 minutes left of trading on the 8th. December 9th, before trading, they halted it. They used what's called a U3 halt. It's extremely rare because they don't have these type of circuit breaker halts on the OTC. So this was an extraordinary event market halt that FINRA used. We were left radio silent for almost 100 days before FINRA came out with an FAQ. There was several inconsistencies in that FAQ. Some of our community and shareholders that have been researching and following the situation answered FINRA's FAQ. And FINRA actually came out with an amended version of that FAQ, changing some of their language once again because of what some of the shareholders and community responded with. Just after this FAQ came out, and that was, I believe, March 16th when they came out with this FAQ, on April 1st, one of our community shareholders got a response back from a FOIA that he had been sending in, and it showed that FINRA, and this is top brass at FINRA, this is the CEO, this is the head of enforcement, this is the head of markets and trading, on an email chain with undisclosed members of the SEC, and they had been talking about the possibility of fraud within MMTLP since November of 2021. So they had been talking about this the entire time it had been trading, and this email chain had gone on all the way through December 5th, which was the day before the first corporate action came out. And I believe on that day or the day before, they had even talked about blue sheeting MMTLP and MMAT. So that's kind of the storyline of MMTLP. And 𝗖𝗢, I'm going to pass it back over to you.
Okay, great. Thank you so much. Guys, I was remiss in not letting everyone know we did put some resources up into the nest. So if you are new to this situation, I'd encourage you to go up there and check out some of those items as well. The community members can do that too. So guys, we're going to roll into our questions for Rob and Wes. And Curtis is going to start us off with how did we get here? Curtis, what are your questions?
Thank you, 𝗖𝗢𝗡𝗘𝗖𝗧. So as Huck just described, a lot of the invested community members here from MMTLP have had a forced education as to some of the problems that have led to this situation, whether it be a lack of enforcement, exemptions and loopholes, fraud, the leveraging of U.S. treasuries by the Fed to create liquidity in the secondary market. But for Dr. Shapiro, Rob, I'll reference you going forward. Rob,
Sure.
What do you see as the greatest threats to the integrity of the U.S. capital markets?
The lack of enforcement. because it's the certainty of enforcement that gives people the confidence to invest in these markets. Lack of enforcement in this case, starting with property rights. But it goes far beyond that. We have a financial system which runs largely or significantly on private information shared between large financial institutions, among large financial institutions, and incredible concentration. So there's virtually no competition. That's why the profits of these institutions are no longer market-based, they're cartel-based. And because they occupy such a central position in the economy, the regulators have in effect blessed it. And if you need any proof, just think of 2008 and all the people in finance that were indicted. None, despite the fact that there was acknowledged fraud. Instead, there were simply fines, which are cost of doing business. So I think lack of enforcement is really, to my mind, the central threat, the greatest threat to the integrity of the markets.
That's such a great segue into a second follow-up question. And I know you definitely had a hand and influence within Reg Show. How has Reg Show fallen short, specifically in regards to diminishing the principle of supply and demand in the name of liquidity?
Well, again, it's not enforced. I recently took a look at about 3 months of the Reg Show list, and there were stocks that were on the Reg Show list for 3 consecutive months. That is every week for 3 months. And under the rules of Reg Show, that should be impossible. That tells you it's not being enforced. But even more important, I think, is the fact that the forms of manipulation, in particular naked short sales, that is the ability to short a stock without limit and without cost. Because Reg Show focuses on that, even though it's not always enforced, the certain broker dealers and funds have found ways to get around them, to get around the definition of fails to deliver. So the enforcement is mainly too narrow. It doesn't look at ex-clearing. It doesn't look at the use of retail accounts to provide shares to borrow. It doesn't look at the proliferation of derivatives that have the same impact as naked shorts.
Yeah, do you view enforcement that is too light-handed to be the same as a lack of enforcement? It's not even an active deterrent?
Yes, I think there is a lack of enforcement, but this really goes to the collegial relationship between the regulators and the financial institutions. Again, these institutions occupy such a central role in the economy right now and in maintaining the stability of the economy that the regulators simply look the other way. And those who lose are smaller shareholders.
Thank you for that. I want to introduce Frank next, Frank 𝗪𝗍, who has been an outspoken alternative media advocate for MMTLP amongst other heavily manipulated tickers within social media. So Frank, would you mind asking the next question?
This is Wes.
Yeah,
Kitchen.
please.
Can I just add a few comments just to give you some additional perspective? So first, if you look at this historically, which of course 21 years litigating this, I've had to. There's too many coincidences in the late 90s that culminate in where we are today. First, the DTC buys the National Securities Clearing Corporation. What is its sole purpose? To lend stock. And if you go and look at Susan Trimbass's book, Naked, Short, and Greedy, you're going to see that the fails to deliver back then were minuscule compared to what they are today. Number two, they pass the Private Securities Litigation Reform Act about the same time, more or less. And what that means is you can't even get discovery until you beat a motion to dismiss in a securities claim. Number three, they take out of the civil RICO statutes the application of racketeering, which is treble damages, plus in some cases attorney's fees, depends on where you're suing, if you bring a state claim versus a federal claim. But under the federal statute, you could no longer apply the laws of RICO to a securities fraud claim. Quite incredible as it relates to the coincidences there. Then what happens is Rob, myself, and others lobby and spend a lot of time helping get Reg Show passed. That comes into being January 1 of 2005. At that point, they grandfathered in all the fails before. In other words, if it happened before Reg Show, you don't have to deliver. Well, ultimately, we fought that, and that got changed over time. We then fought for an anti-fraud exception that came in. But today, the biggest loophole in Reg Show is the bona fide market maker exception. If you look at what Citadel was just fined for, the millions and millions and millions of trades marked long versus short, and the fact that if you look at their trading, I can't talk about a specific case, but I'll just tell you in general that a market maker is supposed to have the same amount of sales versus buys to make a market. But what you'll find if you look at even the SEC enforcement actions is that's not happening. Their sell side is greatly disproportionate to their buy side. Go read, and there's several other complaints, Savvy, just to update you guys. Number one, go look at the Harrington complaint, and most importantly, probably the most important securities decision that came out in the United States is our case, and a very brave judge. There was just an article written on it today in Harrington, which stands for the proposition that brokers are no longer just liable for their own illegal trades. They are potentially liable, or they are liable if they're reckless in not enforcing legal trades through their platform. So let's say Merrill has 20 customers that they use Merrill's platform. Well, if they're doing illegal trades, if you can prove recklessness, et cetera, the other predicates we call it, then now the broker's liable for all of it. So that changes the accountability. Secondly, I think that you got to add to the list of the consequences of it's killing jobs, it's robbing retirement accounts, it's killing technology. And of course, as Rob said, the lack of enforcement is a big piece of that. But also it is the fact that they're not paying enough attention to this based on this collegial relationship that he refers to. So the consequences ultimately are you're not going to be able to, especially in the biotech industry, develop new drugs and other things that are going to be beneficial to all of us if you're a small player. Essentially, it causes small players to be at risk because they absolutely unequivocally have the ability in the current environment to rig the system to where they can put you out of business, and they make more money killing you than they do helping you build up a company and make money on the appreciation of the stock. I could talk more, but I'm going to leave it at that.
Don't worry, you're going to have a chance to do that, Wes. It's like you were just reading our minds. So, guys, just so you know, the Warsaw-Bernstein decision, which Wes litigated, that is the Harrington case that he's talking about. The post is up in the nest, so if you guys would like to take a look at that. So now we're going to go to Frank. Frank, you have a couple of questions for the gentleman.
Yeah, thank you, Junk. Thank you, Busy Curtis, Wes, Dr. Shapiro, Rob. Thank you guys for setting this up. I've taken a couple notes here, and I love what you guys have had to say already so far into this space call. But just quickly, considering the proliferation of
So somebody
failures
needs to mute themselves. I can't hear you. They're talking over you. Okay.
Go ahead.
Yeah, all set? Cool.
Yep, we're set. Go.
Yeah, yeah, thank you guys. Considering the proliferation of failures in trade settlement, is it time to eliminate the market maker exemption? Is it time to eliminate short selling in general? And do you think that alternative media platforms such as Twitter and even independent journalism have the power to influence regulators to take action through consistent pressure? So this could be towards Wes or Rob.
Wes, do you want to start?
Sure, you know me, I'm a talker, so you got to put a choker chain on me. Okay, so I'll try to make it brief. I'm sorry, your first question was about the market maker exemption. Absolutely, that needs to be eliminated. And again, I can't talk case specific, but I can tell you in the 3 or 4 cases we're doing due diligence on right now, that market maker exception is being abused in every case. It is the one remaining loophole. But don't forget, the phrase is a bona fide market maker. What we're seeing is not bona fide market making. We're seeing shorting funds. We're seeing killer whale shorting funds. That's the bottom line. And incidentally, whatever we think the imbalance is between the sell side and the buy side, which is prevalent in all of this, it's going to be much more. You know why? Because the regulatory action where they just gave them a slap on the wrist, if you look at the billions of shares, go look at the enforcement action against Citadel recently. The billions of shares that they mismarked. Why did they mismark it? Because guess what? That doesn't go in your short interest. That doesn't go on Reg Show. It doesn't go on anything, okay? Because it's long. It's not long. It's a disguised short. And incidentally, go look at the number of fines issued by the SEC and FINRA for this. It's like hundreds of various fines. So they've been doing this for decades, not years, ever since Reg Show got passed. So yes, they need to eliminate it because I say a measurable percentage, I don't know what it is, my guess is 20, 30, 40% of this issue is being done under the auspices of bona fide market making. And then what was your second question?
Thank you for that. Yeah, so the second question was, do you think that alternative media platforms such as Twitter or even independent journalism have the power to influence regulators to essentially take action?
Absolutely. The MMTLP community is the best example. What you're seeing now, so for every one of your listeners, double down on what you're doing. In the 21 years I've been doing this, I've never seen a time, and I think Rob will agree with this, I've never seen a time where there's this much awareness, this much discussion on this topic, and frankly, including congressional discussion. Look at the letter that was written yesterday that was just published. I'm trying to think the congressman that did it. I don't think it's
Senator Mike Crapo.
Yes, Senator Mike Crapo. Thank you. And look at the number 4 request in his letter. He wants the count on December 9th for MMTLP. Now, is he going to get it? I don't know. But you know what prompted that? Because I've devoted another 100 or 200 hours to dealing with attorneys, including another one this Thursday, of various congressional men and women and their staff, teaching them about this and showing them documents to prove this that I can share. A lot of it I can't share because it's subject to a protective order in a case. So at the end of the day, the reason Congress is doing what they're doing, whether it's going to bear any fruit, I don't know, is because of the thousands and thousands of emails they've gotten from pissed off MMTLP shareholders who got robbed, who basically they stole money from, in my view. Just like I said on Fox Business, it's basically stealing, the simple version of it. So at the end of the day, the answer is unequivocally yes. In fact, double down on what you're doing. All your congressmen, all your senators, all your regulators, everybody. This MMTLP thing has been a very, very fruitful effort in causing more exposure, much like Overstock did in one of our first cases. Rob was Rob and I go back that far. He was in that case too. So at the end of the day, each thing we do, each case we bring is going to bring more awareness. Now, mind you, people ask me, well, you didn't, how much did you settle for? I said, that's none of your business. Why don't you take one to trial? Well, number one, that's the client's decision. But most importantly, we're creating awareness. We're gaining documents. And incidentally, the SEC can subpoena those documents. FINRA can subpoena those documents that we get. Why? Because the truth is, separate and apart from the lack of enforcement, they're just outmanned, in my view. Every law firm we're against has 2,000 or 3,000 lawyers. Now imagine for the top prime brokers, they each have their own law firm. So add it up, 2,000 or 3,000 lawyers times 10 prime brokers, that's 30,000 lawyers. You think the SEC and FINRA can take on firms with 30,000 lawyers, and that doesn't count their lobbyists? Think again. So all of that counts. Keep doing it.
Thanks for that, Wes. Dr.
Thank you, Wes.
Shapiro, did you, thanks, Frank, appreciate the question. But Dr. Shapiro, I wanted to toss that to you. Do you think it's time to end the market maker exemption, short selling, and what kind of influence do you think that social media has on regulators, if any?
Well, I think if we can enforce the legitimate market maker exception, then we need to get rid of it. And Wes is absolutely right. There's a total failure to enforce it. And so this just becomes, another channel through which these manipulators can operate. And absolutely, I think that public pressure is the only thing that can counter it, frankly. And in particular, public pressure brought to bear on on the people who actually could have some direct effect. And that's in particular the SEC. FINRA is much less responsive. FINRA is like the DTCC. It's a self-regulating organization that's owned by the industry. When we first started on this, it had taken 10 years of public pressure on the SEC to open up the books of the DTCC, because the DTCC had said there's no such thing as fails to deliver and naked shorting, except in very exceptional circumstances. And finally, the SEC was under so much public pressure for so long, and in particular congressional hearings about it, that they sent their own economist into the DTCC and said, you got to open up all your records. And lo and behold, she finds hundreds of millions of fails to deliver on a daily basis. So public pressure is really the only thing that can counter both the collegial relationship between the regulators and the regulated, and the brute financial and political power of large financial institutions.
Okay, thank you so much. Now, gentlemen, I'm gonna call you here. Neither of you chimed in on the opinion about whether it's time to end naked shorting and short selling. Of course, naked shorting is illegal after a certain amount of time, but is it time that we eliminate short selling in the market as well?
Well, as an economist, I've got to say no. Short sales bring in negative information into the market. And it's if you eliminate short sales, the only information that we can get into the market directly is positive information by people buying. You would get, more, shares that balloon up on false positive information, or real positive information, but the negative information doesn't get into the market. Short sales are a way of introducing negative information about about companies into the market because somebody's willing to make a bet that the price is going to go down, and that's information the whole market sees. So you can have a really well functioning market without short sales, but you also can't have a well functioning market if the short sales are naked.
Yeah, I would chime in just quickly and say that naked short selling needs to stop. There is no other asset that I know of that you can sell it, give the buyer you buy it, give the seller the money, and you don't get delivery of your asset. That doesn't apply to houses, cars, anything. This is its simplest form. It's got to be eliminated. You must impose criminal penalties and you must impose substantial fines and injunctive relief against them from trading. And it must be enforced. Otherwise, we're not going to get there. I do agree with Rob. Personally, I'm not a fan of short selling at all. I think it's disgusting. But nonetheless, I get the point Rob's making. More importantly, my additional point is you can't eat the elephant, at one time. You got to eat a leg at a time. And you're never going to get that done in any, probably in my lifetime, maybe ever, because of the economic reasons Rob's articulated. So I think, as a goal, trying to eliminate short selling is not a realistic goal. Let's talk about what we can get done, again, a bit at a time, kind of like the modernization of the beneficial ownership reporting just come out with the SEC. It doesn't really address the key issues, but at least it's creating more transparency and more reporting requirements. So it's a benefit. It's a small benefit, but it's progress. So.
Awesome. Thank you, gentlemen. Now, Wes, you already touched on some of these again, but I wanted to delve into some of the court cases because we are definitely seeing a piercing of the veil and constitutionality and practice and regulations being challenged left and right. And so I wanted to get your opinion on, I'm going to highlight just a couple of them. You already spoke about the Harrington case, which you litigated with 𝗪𝗧𝗪, and congratulations on that decision. But I want to touch on a couple more and then get your opinion on which ones have the potential to have the greatest impact in the much needed market reforms. So, of course, what we're seeing, and I know that you're involved with DTII, you've got Alpine Securities versus FINRA, where Alpine is actually challenging the constitutionality of FINRA's enforcement actions and the denial of the 7th Amendment, and that is the right to a trial by jury. We also seen that in the Securities and Exchange Commission case, v. 𝗪𝗧𝗛𝗧. That one is actually coming before the Supreme Court next month on the 29th. And then there's a couple other cases as well. So what are your thoughts on those and their ability to impact the market? What is the implication of FINRA's enforcement action and SEC's enforcement action being stripped away from them?
Well, I think there's two sides of that coin. First, needless to say, I'm not a fan of Alpine Securities, but let's put that issue on the side. I have to tell you that having represented some executives of some of these public companies, I find that going in front of a administrative judge with the SEC is no different than going in front of a FINRA arbitration by the industry. It's really not a fair trial. So I'm big on jury trials because a jury of your peers is the most accountable people group to seek truth. Yes, they come with some biases, but typically you root those biases out on voir dire or voir dire, as some people call it. So ultimately, I may get stoned for saying this, but I agree with Alpine's point that the SEC should not be the sole place that you can adjudicate issues. You ought to be able to have a jury of your peers. And that applies, frankly, to any litigation. Secondly, I have no idea. And I think, incidentally, the word on the street is the Supreme Court is going to probably go that way and say these other oversight industries, like the SEC, can't strip away the right to a trial by jury, which is a separate issue. So that's that. Secondly, I will tell you some other cases that you need to look for. I'm not of record in this case, but I'm involved in it and have a financial interest in the case, is Northwest Biotherapeutics. That's a company that I went and listened to how their brain cancer drug for glioma has allowed people to survive for 15, 17 years. I listened to the testimonials myself just to get, emotionally involved with the client and their technology. So this is a perfect example where Wall Street doesn't care that they can save lives. They're trying to kill the company. That the oral argument, this is public knowledge, the oral argument for the motion to dismiss is coming up in about a month. Cohen Milstein is the lead in that case. They frankly get virtually the vast majority of the credit for where the case is today and where it's going to go because they're lead in the case. And so what you're finding is other law firms are coming into this space because they now see it's real, it's true, and times are changing. We've been making, good law in state courts, Warshaw Bernstein, Alan Pollack, and myself, and our team. It's a whole team effort that includes Rob, and of course, are now doing it in the Southern District of New York.
So, Wes, let me ask you, is an easy remedy to this challenge to their constitutionality in terms of denying the trial by jury for these enforcement actions to be litigated in federal court? Is that the easy solution?
I think it is, and I think it will go faster. Things, at the administrative level of government, I've never had a good experience with, just to be candid. There's no consistency. There's no, absolute set of rules. Like in federal court, you have the federal rules of evidence, and state court, you have the state rules of evidence. Each individual court has its own local rules, which you also have to know, but they're typically consistent with the federal or state rules. And so I think you're going to have more consistency. I think it's going to be more expedient. And I think the federal judges aren't, bought and paid for institutionally, like some of these administrative courts, in my view. That's my view.
Okay, thanks for that, Wes. Now, Wes, you already spoke about the Harrington Global Opportunity Fund. That's the case that you litigated with Warshaw Bernstein. And that, of course, was holding broker-dealers responsible for the nefarious actions of their clients. But I wanted to get Rob's perspective. Your perspective comes out through your arguments. But Dr. Shapiro, do you expect this ruling to be challenged?
Well, that really is more Wes's expertise than mine. But any ruling that leaves one side dissatisfied will be challenged.
Okay. Well, let me ask both of you a question. With this, what changes do you expect to see from your broker dealers? Do you see them canceling transactions? Do you see them force locating? Do you see them margin calling? What changes do you expect to see in the brokers from this decision if it does stand?
I'll have to go first. So what I think happens is, and I think it's starting to happen now, is they're going to have to the enforcement arm, don't forget, every prime broker, every broker dealer has a compliance officer, okay? And that compliance person is responsible for making sure all the rules, regulations, and laws are complied with. That's the simple version. That person is now going to pay much more attention. Why? Because the liability they had from their own illegal trades gets multiplied by making the number up 10 times the liability if they're responsible for their customers' nefarious actions, using the phrase you use, Savvy. So the exposure that this ultimately exposes them to, the dollars that this exposes them to, the contingent liability, I would call it, that it exposes them to from an accounting perspective, is enormous unless they are following the rules, regulations, and laws. And why wouldn't we expect them to do that? So I think it's an accountability layer of a first impression, although I will tell you, Judge Schofield's ruling is consistent with some other cases around the country, and it's most importantly consistent with a lot of enforcement actions by the SEC and FINRA. Why? because broker-dealers have an affirmative duty to supervise their platforms and make sure nobody is committing crimes or illegal activities on them. It's just never really been put this much in the public domain in a private cause of action versus a government cause of action. There's typically a disconnect sometimes between what the government can do and what we can do. Now a private citizen can do that, which again is consistent with a couple other cases. I don't remember their names. So it's not like Judge Schofield was the first, but it certainly was the first in this form and in the definitive way that she articulated it in her opinion, which is a groundbreaking opinion. I encourage everybody to read it.
Yeah, absolutely. Thanks for that, Wes. Dr. Shapiro, I wanted to ask you, in addition to the elimination of the market maker exemption and looking at all the failures of the regulators to regulate and fulfill their missions to protect investors and to secure the integrity of the market, is it time for the U.S. Department of the Treasury to assume responsibility for what SEC and FINRA have failed to regulate?
Well, I think certainly the Treasury has a space to be more active here, but I think the department which could assume more responsibility and have a real effect is not the Treasury, but the Justice Department. You know, these when these rules are violated, whether it's for naked shorting or spoofing or virtually any kind of market manipulation that involves large broker dealers carrying out the manipulation, fines have no deterrent effect at all. It's just a cost of doing business. And for every one case in which it's discovered, there are another 10 or 15 or 20 where it's not discovered. And mainly because, as Wes said, the information is in the proprietary records of the broker dealers. And you can only get access to them if you survive a motion to dismiss, which is to say, if you are willing to invest several years and a great deal of money in the process. But you send a couple executives to jail and for violating the law, and that will get the attention of a lot of people on Wall Street. And because they're doing the same thing. Although let me say, having been through a lot of these cases with Wes, there are some real bad actors among the broker dealers and others who are not as bad actors. I'm not willing to say they're good actors, but there are some. There was one case in which the compliance officer communicated to the number 3 person at a very large broker dealer investment bank that they couldn't carry out a series of very large manipulative trades. And the top executive's response was, screw it, do it. The compliance officers are advisory. They advise, executives at these companies, and some of them are prepared to ignore it. Now the decision creating personal liability, again, gives a real incentive to the compliance officers. But you cannot, we can never forget how much money has been at stake in these manipulations, in all of these manipulations.
Rob, are you still there? You cut out for a minute. He may have gotten a phone call. Guys, give me just a second. Dr. Shapiro, are you there?
You have to mute yourself.
I'm sorry, what, busy?
Dr. Shapiro, you need to unmute yourself if you're going to speak, sir. He might have got a phone call. Let's just give him a minute.
Yeah, and Savvy, I have about 16 minutes. I allocated an hour for this. I'm sorry, but that's all I have today.
So. No worries. We're going to come up. Actually, I've got the next question for you. So let me go ahead and, Wes, in light of the recent news coming out of MetaMaterials, we've got some burning questions from the community. So I'm going to read a quote. You might recognize it. Quote unquote, based on the initial analysis, we believe this has the potential to become the motherlode of counterfeit shares. The scale and complexity warrant exhaustive investigation, and we are prepared to relentlessly pursue justice for Meta and its shareholders. Wes, let me ask, do you have
that sounds familiar?
Yeah, right. So, Wes, I recognize you may not be able to answer, but if you can, do you have an update on those statements from 4 months ago?
All I can tell you is, and I've put this on a record in a couple different places, is that we're very close to completing our due diligence. And I will tell you, I still believe that that statement is true. I will tell you that, in my view, I've never had a lack of cooperation from normal places that we get cooperation, ever. However, fortunately, Meta hired our legal consortium, which is 𝗪𝗪𝗧𝗛, myself, and all of our consultants, including Rob. And in doing so, set us out on this journey to go find all this information. The reality is, as Rob says, is that in order to file a claim, you must have a base level of information sufficient to beat a motion to dismiss. Okay, and I know that people in the in the GameStop community, the MC community, who I out of courtesy still talk to them. I gave up on trying to help that group just because I could never get the company to cooperate. Well, in this case, Meta has cooperated fully, and we've been burning the midnight oil, discovering what's there and here and there. None of it, I want to be clear, is guaranteed to beat a motion to dismiss. But I anticipate, let me say it a different way. I'm hopeful that very soon we'll be filing a claim on behalf of the company to get information. And then once we have that information, I expect us to file other cases in association with that, or as a follow-up to that. It's an arduous process. I know it makes everybody pull their hair out, but we want the best chance we can, ladies and gentlemen, to beat the motion to dismiss. And if we can't do that, then ultimately the claim is gone. So it's a very serious undertaking. We're always going to give it our best shot, because at the point of litigation, this is public knowledge, a good portion of what we do is based on a contingency. So at the end of the day, we are aligned with the company and its shareholders to try to figure out a way to make everyone whole. To do that, though, it's got to be done typically in phases. To do that, you got to start with the best plaintiff that has the ability to beat a motion to dismiss and gain the information. I will tell you, we're being fought at every level by everyone, especially the governmental organizations, and getting some of the normal information we're able to get. And I don't want to get into what my thoughts are on that, because it gets pretty dicey as to what, how that's being handled on the other side by the government. And because I can't prove what I would be telling you. So at this point, I don't like making statements that I can't back up.
Sure.
So that's the update. So I would remain cautiously optimistic. I do think that the company is committed to taking this to the mat, and that's the most important thing. The companies that don't, frankly, are really doing a great disservice to their shareholders and breaching their fiduciary duty, in my view, to the company, which indirectly is breaching it to their shareholders. So just know we're doing the best we can. It's an enormous job, and all of our team is working very, very hard on it. We just spent 2 days in New York working on that case itself. So that's where it stands.
That's fantastic, Wes. It's nice to know that even in light of the most recent breaking news on the last 2 days, that your relationship, Warshaw Bernstein, your firm, is in a go forward position with me. So we look forward.
Yeah, the thing with George is what it is. George is a friend, and I thought he was a great CEO. But you know, the reality is, I'm not involved in their business. I don't know what's best for the business. I do strongly support the board and Jack, who's their CEO. I'm sorry, who's their chairman of the board. So Jack is a brilliant man and a no baloney guy. So I don't know what all went on there. I don't need to know. That's not my wheelhouse or my job. I don't think it's going to impact anything we're doing. And even the company's lawyers, Wilson Sonsini, who are typically on the other side of the V, have no issue with our presence. So I can just say that. Okay.
Thanks for that, Wes. I appreciate it. Guys, we've got a couple questions from Huckleberry. Huckleberry, welcome to the mic.
Hi, thank you. Sorry. So this one's for the panel, but what would you say the appropriate auditing tools would be that would provide an accurate share count for MMTLP? And which of these auditing tools captures the foreign trade data, if any?
Dr. Shapiro, do you have some thoughts on that?
Well, I'm trying to think. I think that, an audit of the shares, there are entities which, presumably the SEC knows how to do this. Would the SEC do it? It certainly falls under their responsibility, but I think I would trust a outside audit, frankly. And legally, I don't know how that would could be done. Wes may know.
Well, I'm sorry. Go ahead, Ron.
There are so many fundamentals in this case that are unknown. I don't understand how it happened that the shares began to trade. And that remains unexplained. There has been no real accountability for what's happened, either with the SEC, but in particular with FINRA. If you could get a court-ordered audit, would seem to me to be the most reliable way to go about it. Wes, what do you think?
Well, I think the audit's a great idea. That was started in a bankruptcy case with Sorrento here in the Southern District of Texas. I think they've already announced that we're now going to be representing them also. So I think that is a good starting place. At the end of the day, I will tell you, and we don't have this conclusively proven yet, but I have lots of evidence that it's occurring. Your second part of your question was, how does the foreign, trades that stem from outside the country affect this? There's clearly been a shift in the last 2 or 3 years in this space, in this litigation space, I call it, to where we're discovering more and more trades coming out of Germany, out of Italy, out of London, out of which is Euroclear, out of Scotland and Ireland, and other places that are just crazy. It is my belief, my strong belief, that a good portion of that trading is being done by people in the United States who set up foreign entities to do that. Why? Because there really aren't any sophisticated rules. There's no reg show over there. There's no other things that would principally govern this illegal activity. Although, you notice that Korea, I think it's Korea, essentially popped somebody, I forget who it was, for basically naked short selling, and they consider it illegal. So you've hit upon a topic that frankly is in the baby stages of discovering it. But my guess is it's another whale. It's additive, measurably additive to clearing, dark pool trading, high frequency trading, and direct market access trading, which again is all done, under the dark of night for the most part. So that's got to be factored in too. I do not know, and to finish your answering your question, whether that's being calculated in the numbers that we're looking at. I do know in the last space call, and correct me if I'm wrong, but I'm pretty sure we touched on this topic, and I posted some stuff on the platform when we last year, Savvy, or maybe this year, Savvy, discussed that. I put up the list of fails in various types of securities, abroad, and it was staggering, trillions of dollars of trades. So it's much more than I can tell you we're identifying here. What that number is and how to capture that foreign number, I don't yet know. But I'm with Rob. Get an outside auditor that's not, spoken for by the industry to count the shares. We know how many. It's 160 million plus a little bit of real MMTLP shares. And how many did each broker have on December 9th? I think it is 8th or 9th, somewhere in there. I've got too many cases, so my memory's not perfect. But basically, that count's pretty easy to get. My guess is they already have that count, and they're trying to figure out what to do with it. And some of that, sadly, is governed by some of these account agreements. Some people have cashed out. Some brokers have taken the position that they're cashing out their customer at the lowest price that MMTLP traded for, that type of thing. So there's a lot of gamemanship going on that we're monitoring. But in the meantime, if we do file a claim, which is my hope, and we can beat the motion to dismiss, we will be able to get those numbers. And my guess is they will be staggering. That's my guess.
The motherlode of all naked shorts, right?
Well, that's my gut. But, I certainly have been wrong before, and I hope I wouldn't be in this case. But
Yeah.
we'll see.
Well, gentlemen, we have just a couple minutes left. We're so grateful, and we want to respect your time. But I want to go ahead and turn the mic over to Curtis for just 2 more questions. Go ahead, Curtis.
Thank you. So discussing that and the motherlode of all shorts, what is the economic impact if failures in trade settlement are not addressed in MMTLP? What are the implications for the greater U.S. market and globally?
I think it sets a precedent that essentially stealing is going to be legalized. That's my jury explanation of it. So they simply cannot allow that to happen. And I think what's happening here, and I'll be interested to hear what Rob has to say, but then I got to go in 3 minutes. Basically, the government's idea of what they want to do is converging on what's right and appropriate for the shareholders and the company. And the regulatory authorities don't know how to deal with this because basically, as I've said before in many, space calls or podcasts or whatever, these kind of things get resolved in the streets or they get resolved in the courts. Okay. And the more the regulators think it's going to be the streets, the more response we're going to get. I'd like to say our cases are the most important. But frankly, these emails and contacting people and putting pressure on them and creating awareness and letting them know that they're killing families and jobs and technology that can help us all and destroying our capital markets in the meantime is ultimately, it's no different than the Tea Party. This is a modern day Tea Party issue, and basically it's not going to stop. It has too much momentum now, and the regulators have figured out, oh my God, what are we going to do? So that's kind of that's kind of slowing down the process in my view.
I would just add that the liquidity of financial markets is tied very closely to retail investors, and retail investors invest on the basis of having confidence that they're getting a fair shake in the market, that the exchange is what it purports to be. And you shake that confidence, and it has can have very significant and very negative effects for this economy. Wes is right. You cannot allow this kind of theft to occur particularly in daylight, without really threatening the basic confidence in these markets. And it's not just retail investors; it's also, in particular, confidence by foreign investors.
Yes.
On which our economy depends, vitally. So this has some very broad implications.
Ladies and gentlemen, I've got to go. This is Wes Christian. Rob, thank you, my friend, my fellow warrior who's been on this path with me almost from inception. I appreciate what everyone on this call is doing. Keep it up. Get your friends to double down. Keep it up. Keep it up. But I'm on a tight schedule. I apologize. I've got to go.
No worries. Thanks, Wes. Hopefully we'll continue the conversation another time. Appreciate you so much.
Sounds good. Thank you, Savvy.
Bye-bye. Dr. Shapiro, did you want to continue your thought? And then we have just one more question for you. Do you have time?
Well, I think I finished that thought, but I can take one more question.
Okay, Curtis, go ahead.
Perfect. So thank you again. Thank you both for the kind words about the MMTLP retail shareholder community. And we've I know it's been called out, the organization and collaboration that we've had over multiple social media platforms, and it started off in a kind of chaotic atmosphere. But knowing that the success that we have had with congressional outreach, with email campaigns, there's 4 litigations, there's 1 active petition, there's been media coverage. We're really looking for some of your subject matter expertise on where do we go from here. So we've had recently Senator Mike Crapo that used all of his 5 minutes allocated in the Senate Banking Committee to challenging Chair Gensler on MMTLP and for answers and a failure to respond to inquiries. And then just 2 weeks later, this is all within the last month, just 2 weeks later, we had Representative Ralph Norman and the House Finance Committee again follow up on MMTLP. So we've made successful congressional inroads, but what things do you think that we have the opportunity of leveraging in order to maximize pressure on those that can affect reconciliation and ultimately end the MMTLP fiasco?
Well, I think there are 2 things. One is I think your strategy, I think, is paying off, because you get the attention of senators who then demand the attention of regulators. The regulators have to listen to Congress, if only because Congress controls their budget. It also controls their ultimate authority. The only thing I can think of that would be more powerful for Congress to do, for a committee to do, would be to initiate its own investigation of why the SEC and FINRA have fallen down so badly on this. That's part of the oversight authority of Congress. And the last thing I'd argue, I'd advise is in terms of bringing pressure on these institutions. And, I've spent much of my career advising public officials. is to look for allies who can not only reinforce your case, but broaden the the numbers of people being affected by these kinds of this cavalier attitude, in particular by FINRA, and this kind of ostrich-like attitude by the SEC. To think about, other shareholder groups, and there are also, groups which are dedicated to enforcing the rights of shareholders more generally. I would think about approaching them to see if they can endorse it. The broader the coalition, the greater the pressure is, and the greater the pressure is, the more likely government is to respond.
Definitely appreciate that. You also mentioned the other day about potentially making inroads with the executive branch, which we to this point have not been successful in doing, but definitely appreciate your recommendation and the personal recommendation there.
Yes, and I think I am certain, there are, I would start with whoever is the financial markets person on the Council of Economic Advisors, and with an assistant secretary or a deputy assistant secretary of the Treasury overseeing financial markets, which actually, incidentally, Gary Gensler once had that job as undersecretary of the Treasury for financial markets. So,
how ironic.
Yep. Yes, very ironic. So I hope I've been helpful. Economists live in their own world, but I really hope I've been helpful. This is a cause that I have been involved with for decades. Not because it's particularly, I don't have any significant financial incentive, but I think it is a very broad-based wrong that needs to be righted. So I salute all of you for your efforts too.
Well, thank you, Dr. Shapiro, and we salute you. Of course, you were first read into this situation, I believe, back in January, and so it feels almost full circle to have you back here today. And we greatly appreciate your time and your insights and your advice to us on where we go from here. And we certainly need reconciliation for the MMTLP fiasco. And we certainly appreciate your time. It's been a fantastic space call, and I hope that we can continue this conversation with you again.
Absolutely.
Thank you, Dr. Shapiro. Guys, we're going to go ahead and close down this space in order to preserve the recording. But Busy's going to open up an after space so that we can talk about the information that was put forth here today. So just want to thank everyone in the community and outside of the community for showing up, and certainly to thank Dr. Shapiro and Wes Christian for their information and their time. And hopefully there will definitely be more to come. So thanks a lot, everyone. Busy, the mic is yours.
Thank you, everyone. Please look out for the follow-up space call after this one. Again, thank you for attending.